Good afternoon to everyone, and welcome to this webinar on 5 questions on TP ramifications of COVID-19. I am Guglielmo Maisto and shall open this webinar, but I shall first ask Rijkele Betten, the Managing Director of one of the two organizers, International Transfer Pricing Journal and University of Lausanne, to make an introduction. Please, Rijkele, go ahead.
Thank you, Guglielmo. Well, my name is Rijkele Betten. I am indeed the managing editor of the International Transfer Pricing Journal, published by IBFD in Amsterdam since 1993. This is the first initiative of the editorial board of this journal for holding a webinar on a relevant transfer pricing development. The board is consisting out of Guglielmo Maisto, also from the beginning, from 1993, Xaver, Ditz, Vispi, Patel, Lagarden, and myself. This first webinar will concern the transfer pricing ramifications of the current COVID-19 pandemic. And the seminar is co-organized with the executive program in transfer pricing of the University of Lausanne. M&As are, as you all know, of course, currently facing unique transfer pricing issues in the wake of the pandemic. And we will deal with questions like, for what transfer pricing is optimal, which company and which country should bear losses, if there has to be a change there, if the most appropriate method doesn't fit within the M&E's current transfer pricing strategy, will it be acceptable to the tax authorities? Well, we have chosen a format to keep the time optimal, to use the time in an optimal way. We have questions for each speaker, and then he has a limited time slot for answering those questions. More elaborate answers will follow in articles in our journal. The questions can be asked by using the chat function within Zoom, but of course we have a huge number of participants, so it may not be possible to deal with all the questions within our framework. And now I give the floor to my co-host, Professor Maisto, to introduce the speakers and their questions. Guglielmo.
Thank you, Rijkele. I think we can go to the previous slide, which indicates the segments of the webinar, and I shall go through rapidly through the speakers. We have Gabriella Cappelleri from Maisto Associati. Aurelio Massimano had to be with us, but for serious personal reasons he cannot attend, so Gabriella should be taking the first presentation. Then we have Vikram from the University of Lausanne, and we shall continue with Xaver Ditz from Rijkele and Hamburg, and then continue with Bruno Gibert from CMS Francis Lefebvre Avocat, and come to an end with Richard Collier, who is with the OECD and Associate Fellow at the Center for Business Taxation at Oxford University. We shall have comments at the end by Martin Lagarden and Vispi Patel, who are members of the editorial board of the journal. And then we have the conclusion of Professor Danon, who is one of the co-organizers with the executive program in transfer pricing with the University of Lausanne. As it was anticipated, all participants are in mute, but they can intervene, put questions through the chat box, which you find on the screen, or raising hand with a icon indicating the end, and that can be done at the end of the presentations. On the screen, you can see the slides, which shall be flipped over, and on your right-hand side, you can see the videos, cameras showing the speakers. This being said, I believe we can move on to the first issue number 1. Should limited risk affiliates share the emergency? that is for Gabriella to start.
Thank you. First of all, we know that during this period of crisis, the limited risk entity usually are remunerated with a routine profit at arm's length condition. But now, in this situation of crisis caused by the COVID-19, much entities and groups are experiencing a decrease, a very insignificant decrease of their profitability. Our question then is if the limited risk entities should be remunerated with a guaranteed return, also in case in which independent enterprises, a potential comparable, namely with the same function, asset and risk, are experiencing in 2020 the reduction of the profitability. The first paragraph of the OECD guidelines that is interesting in our opinion is the paragraph 1.129 that recognizes, generally speaking, that associated enterprises and independent enterprises can suffer and sustain genuine losses. This could be due, for example, to unfavorable circumstances and inefficiencies. In our case, obviously, it's important to understand if these unfavorable circumstances can support us in a case of comparability analysis. At this point, it's interesting the paragraph 3.64 of guidance of OECD transfer pricing guideline that states that is not relevant only the financial results obtained by the potential comparable, but it's relevant in some cases and in similar circumstances, the characteristics, the asset, the function, the risks of this potential comparable with our situation. The last paragraph relevant for us is represented of the paragraph 1.109. In this paragraph, introduced in the transfer pricing guideline with reference to the new report of financial transaction, we can consider the new definition of free risk return. In this paragraph, the OECD states, first of all, that the risk-free rate of return as an hypothetical return which will be expected on an investment. But at the end, say also that and concluded that there is no investment with zero risk and the reliability of available proxies for approximating a risk-free rate of return will depend on prevailing facts and circumstances. Also in this case, in the paragraph 364 and in the paragraph 1.109, the OECD seems to focus the attention on the facts and circumstances that characterize the situation and the market in which our company operates. Another point of view, very interesting, is the point of view of different countries. In the next slide, we can compare the approach of different countries to situation of crisis. We try to analyze some cases related to Italy, China, US, and Australia. First of all, I would like to specify that Italy doesn't provide any specific guidance on this point, but we have the possibility to analyze some judgments, some recent judgment, 2018 and 2019 judgment issued by the Lombardy Tax Court. Very interesting is the last judgment that use indirectly the reference to paragraph 3.6465 affirm that the loss-making comparable that satisfy the comparability analysis should not be rejected in principle, but are comparable, appropriate, that reflecting the ordinary situation of the market and the existing global and local recessionary market condition. After the point of view of the Italy related on some specific judgment, we have a different approach of China. In this case, and in other case, the tax administration provides some guidance in relation to the previous economic crisis. With reference to the China Tax Authority, with reference to the 2008 financial crisis, the Chinese tax authorities issued guidance that affirmed that single functional risk entities will not bear any risks related to the financial crisis and were not allowed to make losses. This is a principle very, very strong. But different is the position of the IRS and the Australian Taxation Office. For the IRS, it is important to provide the documentation that should fully explain how the unforeseen business circumstances experienced by the company caused the separate financial results. And it's important to determine for the IRS that those results was determined not directly by the transfer pricing policy adopted by the group or the company. Quite different is the position of the Australian Taxation Office that changed the point of view, focusing the attention on the risks. The tax administration actively contacted taxpayers for a risk review, requesting all information and documentation that can support and justify the reason of the crisis in order to support the arm's length approach used, and in order to individuals understand exactly the source of the financial result.
Well, of course, thank you, Gabriella. Of course, situations may differ from country to country. I think that Bruno Gibert want to make a short comment on this particular subject of losses. Bruno.
Yeah, well, I wanted to make a comment indeed, Guglielmo, on the subsidy, whether when you have subsidy, you can take them into account. You know, in these times, governments are making a lot of subsidy, public subsidy to companies. So whether when you receive a subsidy, you can take it into account in your transfer pricing policy. We don't have guidance on that, and of course, nothing linked to this situation of today. But we had an interesting case law in 2018, Philips France case law, which was followed by my firm, by the way, and in which Supreme Court considered that we had Philips France, who was on a cost plus 10% basis and received a subsidy from the French government. The question was whether they could deduct or not this subsidy from their cost basis. They had done that, and the French tax authorities had challenged this. And Supreme Court said that the very fact to receive the subsidy is not in itself something which is not at arm's length. And as a result, the French tax authorities were not allowed to reject the deduction of the subsidy from the basis of the cost for the cost plus method applied by the French company with its Dutch parent company.
Thank you, Bruno. I think we can move on to the next segment, which is focusing on who is bearing the cost of the conversion. And Vikram, you may like to address that.
Yes, so thank you for this question, Professor Maisto. If we go to the slide and, let me just give you a little background of what's happening around the world. You see that many companies, in light of this COVID-19 response, are incurring a lot of costs. And these costs are typically pro bono costs. Just to give you a few examples, you have many multinationals who are reconverting their assembly lines or using part of their unutilized assembly lines. And they are actually making masks, hand sanitizers, ventilators, swabs, face shields, and you have some telephone companies who are creating apps on a pro bono basis to even locate where people are. And some other multinationals, especially in the transportation sector, they are transporting these products from one country to another country, and they're also doing this on a pro bono basis. And you have some other M&Es who are showing support by making generous cash contributions towards the local hospitals or local authorities. Now, I was reading an article that was published by the World Economic Forum, and according to that article, in that article, there were a list of companies who are incurring these costs. And just to name a few, and this is in the public domain, you have many famous fashion brands such as Zara, H&M, LMVH who are incurring these costs, companies in the personal healthcare sector such as Unilever, P&G, J&J, in the companies in the automotive sector like Volkswagen, which is making ventilators right now, even in India, the Mahindra Group, in the financial sector, companies like MasterCard and the other big banks, in the alcohol and beverage sector, such as AB InBev, which is, instead of making beer, it's making hand sanitizers, as per that article. You have many companies in the consumer durable sectors, such as General Electric, which is making some kind of medical products. Companies in the aviation sector, which are flying the products from one country to another country, such as Airbus, and using their airplanes. And then you have the big business houses like Tata Group in India, or even Nestle Group in Switzerland, which is doing all these pro bono activities, and it's incurring expenditure associated with these pro bono activities. And then you have the big digital companies too, such as Amazon, Facebook, Google, who are in one way or another helping the community. So the issue here is which entity within the multinational group should bear these pro bono costs, such as cost of producing these new hygiene or medical products, cost of transportation of the products, or the costs associated towards, granting, making some contributions towards social aid. Well, the OECD guidelines is very silent on this issue, and a possible solution to this answer would actually be the classical answer that you would give to everyone, is that it depends actually on the business model of the company. Now, transfer pricing at its core, or applying the arm's length principle at its core, is a facts and circumstances analysis. So the facts and circumstances of each situation will actually dictate a possible answer. But in general, a difference needs to be made between centralized business models and decentralized business models. So typically in a centralized business model, where you have one entrepreneur, and this entrepreneur is working with contract manufacturers or with limited risk distributors, with low risk entities, in this kind of business setup, I would tend to argue that these costs should be at the level of the principal, because the principal or the entrepreneur is the one who will actually make the key decisions associated with respect to these costs. So it's a cost that has to be incurred by the principal or the entrepreneur, the centralized entrepreneur, and they are usually the ones who are going to take the decisions associated with these costs. So the decision-making power typically in centralized business models is with the central entrepreneur. And thus, in my opinion, they should be the ones who bear such costs. So for example, if you have a centralized entrepreneur in one country, which is operating with a contract manufacturer in another country, and the contract manufacturer, for example, it's in the fashion sector, it stops making clothes and suddenly starts making, for example, gowns for hospitals, medical gowns which are to be given to hospitals, then the cost of making these medical gowns should be borne by the principal. So if there's a cost of 100 that is being incurred by the contract manufacturer, these costs should be reimbursed by the principal to the contract manufacturer. On the other hand, I would differentiate centralized business models from decentralized business models. In decentralized business models, typically the local affiliates have a lot of decision-making power. And if the decisions to make these contributions or incur these expenditure is coming from the local affiliates, then in a decentralized setup, I would tend to argue that the local manufacturer, for example, which is a full-fledged manufacturer, that entity should be the entity which is bearing the costs associated with such expenditure. Special attention should also be given to centralized IP ownership models, and because sometimes the decisions to contribute to such expenditure also have an impact on the brand image of the entire organization. And if the decision is being driven by the centralized IP owner within a M&E, then possibly a part of the cost should also be borne by the centralized IP ownership model or the centralized IP entity.
Thank you, Vikram. What I can say in this slide is that we have a variety of situations, but on the other hand, behaviors are very similar in the different countries. For instance, reconversion or pro bono activities, and I'm sure tax authority may have common issues to discuss in order to reach an agreement and avoid double taxation in some way, but this is something which should be addressed later, most likely by Richard Collier. So we can now turn to the next comment. We have a comment first before we go to Xavier Ditz presentation. I think we have one comment by Patel, and on this particular presentation, you may like to make a reference to the cost base when there is a cost plus arrangement, how to address better cost determination. So I would ask Vispi to make his comment, please.
Yes. Good afternoon, everyone. The important thing is that in a cost plus model, if the methodology of reimbursing the contract manufacturer or the manufacturer is on a total loaded cost, both direct and indirect costs, then normally speaking, these reconversion costs should be charged to the principal on the basis that the entrepreneurial decision to incur these costs of reconversion were actually directed by the principal entity or the central entrepreneurial entity. And therefore, under normal circumstances, as the risk is to be mitigated for the contract manufacturer, it would be economically correct, probably, to charge the principal on a cost plus basis. Of course, one argument could always be there is that are these costs normal cost and operating cost, or are they non-recurring, non-operating cost? So at best, there can only be a compensation for the cost that is being incurred, because in a lockdown situation where nothing is being manufactured, you're trying to help society, and therefore this is completely different from a normal economic activity.
Thank you, Vispi. We can move to the third issue. It is for Xavier Ditz to address the benchmark for 2020. Please.
Yeah, thank you. Hello, everybody. Good afternoon. COVID-19 poses a challenge for arm's length determination and documentation of transfer prices. One main question is how to manage benchmark analysis this year. This is relevant for the determination, for example, of the profit markup in connection with the cost plus method, the calculation of the net profit margin by applying a TNMM approach, the calculation of a gross profit margin in connection with resale price minus, and of course the determination of license fees and interest rates based on a cut in these examples. It's questionable, of course, if we can use comparables identified in a benchmark analysis based on past years. So usually comparables of the years 15 to 19 should be used for this year. However, from my point of view, there is no doubt that in almost all cases, comparables which refer to this normal economic situation of the past cannot be used for this year, because the economic situation is so different and therefore comparability is not possible. There might be some exceptions in business sectors which remains unaffected by the COVID-19 outbreak. However, from my point of view, these sectors should be limited. So, ladies and gentlemen, what are our options to apply a benchmark analysis for 2020? I would like to continue with the next slide, 10. So neither the OECD nor the German tax authorities has provided guidance for this specific situation. An important question up front is, from my point of view, if it should be possible to allocate losses or a zero result to affiliates performing routine functions. My answer is a clear yes. So from my perspective, in this very specific time, it's possible to allocate losses or a zero result to affiliates performing routine functions. Having said that, it's now the question, how can we then apply a benchmark analysis for this year? And to be honest, I don't see a single solution. I can only come up with a few ideas which I thought about when I prepared this webinar. Idea one is to use comparables of the financial crisis in the years 2008 to 2010. In this time, the world economy was also affected by a very specific crisis, and therefore regarding some sectors, it can be possible to use comparables of these years now for 2020. Then secondly, for me, it's the question if it should now be possible to include companies generating losses in the benchmark analysis. That does not comply with the principle not to include loss-making companies in a benchmark analysis for routine functions. However, now in this time, I think it should be thought about that. And finally, the group-specific result in 2020 can be used to adjust to the comparables found in the past years. So, for example, the benchmarks can be reduced proportionately to the decrease of the group's results. So that was an idea which came into my mind when I prepared this webinar. But at the end of the day, I think it's necessary to look at each specific case to solve these problems. In the end, I have a wish that the requirements for an appropriate benchmark analysis for this year should be reduced compared to normal times. This should be accepted by the international tax authorities, but as a second wish, should be officially stated by the OECD. Thank you very much.
Thank you, Xavier. I think that we have another, in a way, request for OECD to clarify, and perhaps also to the forum on the European Commission, which is for Bruno Gibert also to, in a way, as a task, because within Europe, perhaps we may have time to formulate some recommendation. But this being said, I shall give the floor to Bruno for another interesting subject, which is APA, what to do with APAs, renegotiation, and so forth. So Bruno, please.
Thank you very much, Guglielmo. Good afternoon to everyone. Yes, indeed, a transfer pricing policy can be affected by the COVID-19 crisis when it is in an APA in the same conditions and as when it is not in an APA. So, but the very different is that when you are in an APA, then you have concluded an agreement with at least one tax authority and often two tax authorities. And this agreement is normally binding for a period of time. Very often it is between 3 to 5 years. So the question is whether when you are in such a situation, whether indeed you can change the transfer pricing policy, which has been agreed in this APA situation. Question also is whether when you are under discussion of an APA, whether you can change or not your submission. The key element in this is what we call the critical assumptions. As you know, an APA contains critical assumptions. The text of the APA contains this. Most generally, the critical assumptions are based upon the functions, the risks, the activities performed by the company, but you can also have the economic conditions. And if you look at the OECD guidelines, paragraph 4.146 in chapter 4, it clearly states that an APA can be revised or canceled, and I quote, when business operations change significantly or when uncontrolled economic circumstances critically affect the reliability of the methodology in a manner that independent enterprises would consider significant. As a result, as we do see, the critical assumptions, as seen by the OECD, should lead to be able to take into consideration the effect of a big crisis in the economic conditions and as a result in the APA situation. However, of course, everything depends upon the law which is applicable in the countries, and of course, it depends upon the text which has been agreed with between the competent authorities at stake. Some indications, for example, the United States, the IRS APA template for an APA, which has been released in May 2018, clearly include in the critical assumptions, I quote, the economic conditions phase. So it seems that the US APA competent authority would be willing to look at this. On the other side, as regards the French critical assumptions provisions, it varies upon, there is no public publication of the template, but if you look at concrete cases, in some cases you have economic condition, but in most you don't have. So we will see later on what it gives. As a result, I will look at what to do when you have an APA concluded and what to do when you are negotiating an APA on the other slides. Following slides, please. When you have an APA concluded, of course, the first point is to see whether you are affected, your TP policy is affected by the crisis. And the second, of course, is to see what is written in your APA, what is the critical assumptions written, and whether or not economic situation is included into it. Second point to take into consideration, of course, in an APA situation, the first thing to do is you want to move anything is to get in touch with the competent authority. As you know, an APA is a cooperative process, discussions with the competent authority. As a result, nothing is to be done without getting in touch with the competent authority. And of course, it's better to do that before any change rather than to wait for the annual compliance report. As you know, in an APA, you have to file an annual compliance report, but you file it after the end of any given year. So it is far too late. So recommendation is, of course, to get in touch. Now, the question is whether you have three possibilities to change, no change at all. Second one is to amend the TP policy. And the third possibility, which must be looked at, is to stop the APA and quit. What we can see, globally speaking, the trend, if I may say so, of course, it's a case-by-case basis, as I said, depending on the law and the text of your APA. But the global trend we can see is that it is rather difficult to change an existing APA, even because of the economic conditions. It's not impossible, but it is, the global trend is rather not very open. If we look back, with of course some exceptions. For example, some countries have taken an open stance. You have an interesting report in BNA article of 13 April, where a variety of countries are described. And for example, the UK and Australia has shown an openness to look at the situation. If you look also at the past, at the 2008 and 10 crisis, and you look what the United States did, you know, the US published an annual report, and you see in the 2010 annual report that the US had been amending some APAs which had been concluded in the past because of the 2008-2010 crisis. On the other side of the range, if you look at countries such as India, it is not possible normally to change anything of the APA. And if you look at France, the competent authority has sent a letter to an organization representing business, and they do consider that normally critical assumptions do not concern the economic conditions and that an APA should not be changed because of this crisis. In any case, once again, the advice, if you think you should change something, is to get in touch with your competent authority. And of course, situation is more difficult or more complex when you have a bilateral APA or even a trilateral APA, because you have to get in touch with all the competent authorities concerned, which can have different views on the situation. And final comment on this situation, you must of course expect delays We all know that APAs are quite a lengthy process, but of course, in these situations, given the fact that many tax authorities are working from home, given that they are not necessarily well equipped to work from home, given also that some priority have been put forward, you must expect to have more delay to get anything. A short word on APA underway, that is to say an APA that you are currently discussing. Of course, in this situation, it is easier to make some steps. Indeed, nothing has been finalized. However, you have filed an application, but you have open discussions. It depends, of course, upon the countries at stake. But in this situation, I believe, and from experience, that you can more easily introduce some changes because of the crisis and have an open discussion. You can also consider to withdraw. Very often withdrawal is possible in an APA discussion. You must, of course, be careful to control in a good way your relationship with your competent authority, but withdrawal is something which seems to be possible. You may lose your fee. As you know, some countries have a fee for APA. It's the case for Germany, for example, 20,000 euros, if I'm right. Usually you pay the fee when you open the APA. So if you withdraw, well, you've lost your fee. And last comment on this is, of course, that I mentioned delays for renegotiating an existing APAs. As regards APAs under discussions, which also is a lengthy process, as I said already, you may expect that your APAs which are under discussion may be even longer. However, I can note that some competent authorities, the French one in particular, but others also, have started to develop IT solutions to have conference call with the taxpayers applying for an APA, and also conference calls or video conferences with other competent authorities. So I think this is going to be more developed. This is what I could tell on the APA situation, Guglielmo.
Thank you, Bruno. I think something which I would like to comment very simply is that decisions regarding 2020 need to be taken now, basically, and the tax administrations, as you rightly said, are busy with other current negotiations, and it may be difficult to get a response on a one-to-one basis for taxpayers. So that is the reason for which there is a need for some guidance, at least some general guidance from international organizations. So that will come timely to the topic of Richard Collier. And Richard, I think that if I may ask you also, taking the chance that you have the final, let's say, presentation before comments and the Q&A, if you can include in your presentation, maybe taking 1 extra minute, 2 questions which are put by the audience. The first one is very simple. Some in the audience said, well, the 2008 financial crisis is something which was different. Some companies went bankrupt. They did not even file tax returns. Information was perhaps not available. And so how far can you go in making a comparison with the situation? That is the first question. Obviously, and also Ditz may comment later on this point. And the second one is a point which was already commented by Bruno, I think. If a limited risk distributor should shift the benefit of a subsidy paid by the government to the principal, or so that the cost basis would be reduced or not. If in addition to your presentation you can address those 2 points, that would be very welcome. So please, Richard, go ahead.
Thank you. I'm going to comment briefly on the OECD work to date, and then talk about the issues that are raised for the ALP and possible responses. I'm also going to add on some comments on the two questions you've just raised.
Thank you.
In terms of the work of the OECD to date, that's been quite significant. There is a significant body of OECD material on COVID-19 online. There's an OECD hub containing a large amount of data, and this is in the nature of general data on a whole range of different perspectives. This data does include tax material from the Centre for Tax Policy and Administration, and there are 5 items I'm going to mention briefly in that regard. Firstly, there's a database of tax policy responses, which tracks and is updated for over 100 country responses. There are 2 reports from the Forum on Tax Administration dealing with first actions by tax administrations to support taxpayers, and separately some business continuity considerations for tax administrations themselves. Fourth, there is a report to the G20 on tax and fiscal policy measures in response to the crisis. And then last, and probably more relevant directly to this audience, there's some guidance on certain tax treaty issues, largely revolving around the implications of physical immobility issues. So looking at the impact of the crisis on threshold PE tests and the place of effective management in treaty tiebreaker tests, etc. Now, turning to the ALP, it's no surprise that in recent days, the OECD has been receiving requests from governments and businesses to issue guidance on transfer pricing issues and COVID-19. Let's just turn to the issues raised. And I think the remarkable or the notable thing about the issues raised is that many issues are raised. There are all of those discussed today, plus a whole range of other issues. For example, a question that's already come up today, the allocation of benefits from government support, the question of service fees or royalty payments being paid from loss-making entities and so on. So a huge range of questions is coming up. Now, I'd like to just comment that most of these questions raise issues of a different order to those that have been addressed in the OECD treaty guidance. In the treaty guidance, the commentary is broadly a clarification or confirmation of the existing guidance that's already in the commentary to the OECD model. The questions on the arm's length principle, on the other hand, are often not covered by existing guidance or subject to very little guidance. So that's why I say they're of a different order. So for example, on the question of government support, there's no real discussion in the transfer pricing guidelines of the sort that we now need. And there is some existing discussion of location savings. That's in chapters 1 and 9 of the guidelines, but it's really very limited and it doesn't engage with the topic of government assistance in the way I think we need it to be helpful in this crisis. The current position is that there is an effort underway to explore the option of developing additional guidance on the issues. And I think it's pretty clear what the purpose of that would be. As I indicate on the slide, the objectives of any response would be to seek to provide more certainty and garner more consistency in the approach with a view to limiting disputes or limiting double taxation. However, the attempt that's underway is to seek not just the guidance of the Secretariat of the OECD, but to take best account of the country positions and make the guidance as useful as possible. So what's going on is an exploration of the wider endorsement involvement of delegates through WP6 discussions or incorporating a response in terms of the inclusive framework format. The process, actually, another advantage of the process is not just its guidance produced, but also creating a useful forum for delegates to discuss some of these issues and hopefully refine and improve the thinking on them. On my slide, it also indicates some potential issues. I'm sure everybody wants lots more clear guidance, but I think we need to be realistic about any work and any output. There are a couple of obvious issues. The first is the range and the nature of many of the issues. We're starting to log the issues relating to the ALP, and I've already commented that there are many. Some are at the more practical end of the scale. So for example, some of the issues that we've discussed today about 2020 data. Some, however, present much more searching questions about the ALP. For example, the application of the ALP to existing contracts in a market where survival, not profits, is the goal. There are also differences in impact and in perspective. COVID-19 impacts different countries and different business sectors differently, so there may be differences in priorities and perspectives. And there are also obviously resource constraints for delegates. These factors that I'm talking about make the task of responding more difficult, and they have an impact on the timing. Though it is recognized that it would be important to have a response to these issues by the end of the year. In terms of the next steps, we've already started at the OECD compiling a list of issues relating to the ALP and trying to identify priority areas. Input would be welcome from all stakeholders on these issues in terms of areas where guidance would be needed or where it might be beneficial. And if you want to directly contact the OECD, the usual address of ctp.contact@oecd.org is the place to go. That's ctp.contact@oecd.org. But I'd also recommend strongly raising issues with your own country tax administration who will be participating in the process. The likely output that we're contemplating in our exploration of this issue is a technical paper on the issues not covered in detail in the transfer pricing guidelines. So dealing with questions like the one I referred to on government support and where taxpayer uncertainty is high. And the goal, as I've mentioned, is to deliver that by the end of the year. In terms of the two questions that were asked about whether the 2008 crisis is useful, there are a number of points relating to the crisis that are instructive in terms of the issues it raises in the response, but clearly, at least in an immediate sense, different parts of the business are affected, and it's very difficult to generalize in regard to this question beyond, say, facts and circumstances analysis, which I guess is not giving a particularly concrete response. On the question of, on your second question about should a limited risk distributor shift the benefit or retain the benefit of a subsidy, as has been discussed, there are definitely very different views on this. I think there's some Canadian guidance that had already been in place that suggests that that would not be appropriate. And it may be that the guidance I referred to on location savings would also give an idea, but I don't think there's going to be a blanket response to that, certainly not a blanket response that's going to be accepted unquestionably by all countries. That's the end of my comments.
Microphone, Guglielmo, microphone.
Sorry, thank you, Richard. I think before we move to a couple of comments, I have one point which I'm sure the OECD should address, and which was raised also by the audience, namely the contractual terms. So what does the contract say? What does the intercompany agreement indicate? Because legal arrangement has to be respected. OECD guidelines permit to depart only under special circumstances from the legal terms and the arrangement. So some of the people from the audience indicate what's about force majeure provisions. Definitely, in my view, one would need to look at that, but in real life, I don't think that termination of contracts in situations of third parties is something realistic. It's more likely to have a renegotiation of the arrangement. But if you have a local distributor, you don't terminate a contract for an emergency and basically waste your potential on the market simply because legally speaking, you can terminate the arrangement. So the matter becomes more difficult because the terms of a renegotiation basically to be characterized between independent parties may be difficult, and experienced based on third-party relations that the group may have experienced in other contexts in a different period might help. So the legal arrangement, I think, is certainly something that the OECD would need to address should the OECD decide to consider transfer pricing and COVID-19. This being said, I think that Martin Lagarden is ready to make a comment.
Yeah, thank you.
I'll give you the floor.
Thank you, Guglielmo. The current situation that we are all facing is extraordinary in many ways, and it will go on for some time, but clearly to varying extent in different industries and different business sectors and companies. So for me, as head of global transfer pricing in a multinational group like Henkel, it's still crucial to do an analysis and think about the presentation of the individual facts and circumstances of our case. I still believe that the arm's length principle remains as the guiding framework also in this situation for my documentation efforts now and for my tax audit defense in countries at a later point. And it seems obvious to me that adhering to this principle allows enough flexibility for me is better than prescriptive or otherwise formulaic approaches. So any OECD guidance as outlined by Richard under issue 5 is highly welcome in this regard. I'm convinced that 3 major aspects are relevant to cope with our current transfer pricing challenges in terms of the 5 issues that we discussed today, namely credibility in presenting our individual facts and circumstances as a company. And this has also something to do with trust building in our cooperation with different tax authorities in different countries in a, let's say, cooperative compliance sense. Second point is consistency in our data on one hand, and the interpretation that we build on that basis on the other hand. And thirdly, the economic viability of the transfer pricing measures we implement now with a view to the first 2 points, credibility and consistency. And these 3 aspects guide our current decision-making and advice, which me and my colleagues provide in Henkel to our business unit colleagues. For example, in terms of, firstly, transfer price setting and margin monitoring in a centralized entrepreneur structure. So actually living the profit or loss split in our transfer pricing system in compliance with what we have agreed in our intercompany agreements in place regarding, for example, cost reimbursement or force majeure clause, as discussed by Gabriella and Vikram under issues 1 and 2. Secondly, comparable selection in our internal benchmarking going forward, starting to accept also loss-making comparables to a limited extent, at least, as opposed to our current benchmarking approach, as addressed by Xaver under issue 3. And finally, reviewing our existing APAs, as we do, asking ourselves if and why we really consider it advisable to touch base with the tax authorities involved. So far, I do not think we will. But if so, what is our going-in position? Why do we adopt this position, and what do we want to achieve as an outcome, by when, as outlined by Bruno under issue 4. So fortunately, our management is aware of the challenges also in the tax area, and therefore this is our way forward for the next weeks and months. Thank you.
Thank you. Before we move to other comments, I think that let me pick one question from the audience, which is related to what I mentioned about the force majeure and the renegotiation. I think there is an interesting comment, which basically for which I would ask comments from the speakers, and I would primarily look at Bruno and Gabriella, who haven't commented yet. Really, the point is on force majeure. The question says it is very important the wording of underlying contract, and then it says basically it makes reference to how long it would take to recover the loss. So in other words, if one can consider a renegotiation of the terms of the arrangement to be realistic insofar as the loss can be recovered in a reasonable period of time. So basically, there is a relationship which is made between the loss in the 2020 and the number of years in which the loss can be recovered. Do you see a relation between the two? That is one question. I don't know, Bruno, if you want to comment, or Xaver Ditz. Yes.
No, not sure I have a good answer on that. I mean, it's so much linked to the circumstances, how long you need to recover, how to take that into account, and how force majeure can play a role. It's very hard to have a view on that. I don't know, Xaver, if you have a view.
Xaver? Can we ask Ditz to?
Yes, I'm here. Hello.
Yes.
Yes, it's a very difficult question. From my point of view, force majeure should be possible in this very specific time to reach the flexibility of the arm's length principle.
Thank you. And Vispi, I think you have a comment on something which is related to it.
Yes. Good afternoon, everyone. I think this COVID-19 seems to have brought about a great level of disruption in the economies of the globe. So one of the important considerations which may come up as we move ahead is that, one, there is actually no economic activity in certain spheres of the economy as laid down by the government policies. So actually there is a frustration in doing economic activity because of this heavy lockdown in certain countries like India, Australia, and other countries. So now we come to the most important question, that what happens in the case of financial transactions of lending, borrowing, and other related subjects in consonance with financial transactions. So what we can get out from, or what we can actually perceive from the economic behavior of central banks across the globe is that they are easing liquidity conditions. In India, for example, from where I come, the Reserve Bank of India has given a moratorium for certain EMIs to be paid and give benefit to the borrowers by there has been a diktat from the central bank. So what does all this lead to? So is there a possibility in this type of a situation where there is no economic activity, and perceivably when this supply shock and the consumption shock actually is felt by the industry, whether there can be a renegotiation of the lending and borrowing contracts? Or is it that once something is stated in the contract, it becomes cast in iron? And I believe no, because there are circumstances where under the contract acts of respective countries, there can be frustration of contracts. From a lending perspective, there are market disruption clauses. So therefore, the question that is to be debated as we move ahead in our transfer pricing analysis of this huge disruption caused by this pandemic, health pandemic, which will also automatically become an economic pandemic, is that can, due to very easy liquidity conditions prescribed by central banks, is there a possibility to renegotiate the rates of interest, the terms of borrowing in a manner which does not frustrate the contract, but actually tends to try and get a middle ground so that there is economic activity at the end of the day? For example, no lender would want to just go and recover the money by using the market disruption clauses in their contracts in a third-party situation. There would actually be a negotiation so that a middle path can be found. So my belief is that as we move ahead, especially in financial transactions, depending upon the nature of the transaction, not a simplicity lending and borrowing, there could be convertible transactions of compulsory convertible debentures, option contracts, which may have been entered into. And therefore, to that extent, there is a possibility of renegotiation, in my view, based on the economic circumstances and facts and circumstances faced by the borrower and the lender.
Thank you very much, Vispi. I think we are moving towards the end. Before I turn to Professor Danon, I don't think we have question time. I think we have answered a few questions, but we are running out of late. I think it's something which the International Transfer Pricing Journal would like to mention is about the possibility for the attendees to get a 20% discount on the journal by using the code which is shown here. And I also wish to anticipate that slides should be circulated to the members and to the participants. And this being said, I give the floor to Professor Danon to conclude our webinar, and hoping that everyone was pleased with questions which still remain. Robert.
Thank you very much, Guglielmo. It's a pleasure to be here. Yes, I will not keep it too long, but I think a number of very interesting issues have emerged. One particular issue, and there I contrast the remarks made by Richard in the area of tax treaties, is we are heavily in need of further guidance in the transfer pricing guidelines to ensure certainty. We know, of course, that there are here and there some useful passage which we can use, but indeed there is a clear need for clarity, and in that sense also, unfortunately, a potential for further disputes. I think we talked about disputes arising out of transfer pricing. We talked about disputes arising out of tax treaties. I think another area that we should not forget in these difficult times is, of course, also disputes arising out of bilateral investment treaties, which impose fair and equitable treatment, in particular in relation to emergency measures and subsidies. And I think that should also be brought into the equation. So I'm very much happy that we actually opened the debate today. What I would like to say is that at the University of Lausanne, we're working currently on an issue paper bridging these areas, and we hope, obviously, online in the coming weeks or month, to organize a follow-up session, a table ronde, as we say in French, to discuss these issues, which again have been initiated. But I keep the words uncertainty and disputes, which of course is a little bit worrying. Thank you very much.
Thank you, Robert. Very interesting, say, prospect studies. Thank you to the speakers. Thank you to the audience. Thank you to the University of Lausanne and the International Transfer Pricing Journal. I think we still have almost all the participants are still connected. So thank you very much for attending, and see you soon, perhaps for a second round after the OECD shall be out with some recommendation by the end of the year. Thank you very much. Bye-bye. Have a good day.
Thank you very much.
Thank you.